A very good evening to you all. I would like to take this opportunity to especially welcome our speakers, Dr. Jameel Al Alawi from Bahrain and Joseph Schorer, and together with David Curry, who is going to be our moderator for this evening, both of them from the US, both from Chicago, I just came to know. For me, this talk couldn't have come at a better time. Given the current economic situation, I think companies of all sizes, small, big, large, I think they are all finding it extremely difficult to ferry through these times. Now, as we all know, the word bankruptcy is like a taboo in this part of the world. But I think bankruptcy law, similar to that of Chapter 11 in the US, could be a very vital tool for companies to survive, if they understand what it means and they know how to use it correctly. I'm sure everyone who's attending this evening is looking forward to the talk from our panel of experts. So let me ask our General Secretary Madhavan to introduce our moderator for this evening, David Curry, who then will take on the proceedings further. Thank you.
Thank you, Raj. Good evening, ladies and gentlemen. Now, I always look at the company like a person, because the company is called a legal person, unlike us who are all natural persons. A company does everything a human being does, being born at the time of incorporation, getting married by merger or amalgamation, and having a subsidiary by like having a child. There's one major difference between a human being and a company. A company is assured immortality by virtue of law, by the basic tenet of a limited liability company, which is known as the perpetual succession. A company is independent of its partners or shareholders, and whatever happens to them does not affect the company, and it continues forever. However, there are situations when the immortality can be impaired by terminal illnesses, where euthanasia or mercy killing is the only solution. And today's session is, the experts are going to look at that. I have the privilege of introducing Mr. David Curry, who is the moderator. Mr. Curry focuses his work on commercial law development. As a legal advisor for the Commercial Law Development Program of the US Department of Commerce, he has worked for many years with the government officials in emerging market countries to help improve their commercial laws and build capacity to implement those laws. Previously, David practiced law with the international law firm of Mayer Brown, where he was a partner for 25 years, specializing in business insolvency. So he's the right person for today's subject. David is also a frequent visiting professor, teaching business law subjects at universities in Eastern Europe and South Asia. All yours, David. Thanks a lot.
Thank you for that introduction. Good evening to everyone. I'm very pleased to be here today and to be able to start off the program by introducing our two outstanding speakers. But before I do that, I'd like to first thank the Bahrain India Society for organizing this event. As both of you have said, this new insolvency law that our speakers will be discussing today is a very significant development for Bahrain. And I think it's highly important to bring it to the attention of the business community. And I say that because, as I see it, this new law truly revolutionizes the approach for dealing with business insolvency in Bahrain. And as our speakers will be explaining to you, it does it by making it far easier to save deserving companies that are experiencing financial difficulties. And it does it by allowing them to reorganize and to rehabilitate their businesses and emerge from insolvency as healthy companies again. In my opinion, with having studied this law and worked on it, I think Bahrain now has what I would call a best-in-class insolvency law. Our first speakers to talk about this best-in-class law will be Dr. Jameel Al Alawi. Dr. Jameel is the Senior Legal Advisor with the Economic Development Board. And for the last 10 plus years, he's been charged with developing a number of he was the principal drafter of this law. He knows presentation on how companies can be reorganized under the law. So he's going to focus on the reorganization provisions. Joe is similarly highly qualified to speak on this topic. As a longtime lawyer with the esteemed law firm of Kirkland Ellis, Joe's been the senior lawyer on many large corporate reorganization cases. A notable example of that is the United Airlines case, where Joe was the senior lawyer on that case and helped guide United through a successful reorganization of its fares so that it could emerge from Chapter 11 and be a healthy airline again. In addition, Joe is also a professor, and he's taught commercial law subjects for many years at the Loyola University School of Law based in Chicago. And he just recently finished a class this summer that he taught on insolvency law at Northwestern University. So we have two absolutely outstanding speakers for you this evening. Finally, before I turn it over to the speakers, just on a procedural matter, I want to let everyone know that after our speakers have concluded their presentations, we've reserved time at the end for questions from the audience. And facilitate that, we'd like to suggest that as the program progresses and questions come to mind, that you send your questions using the chat feature on your Zoom screen, and then our speakers will take them up during the question and answer period. So with that, I'm happy to turn it over to Dr. Jameel.
Thank you, David. Just a correction, David, I was not the principal drafter. The drafting was really a collective effort, and I was honored to really make a modest contribution to the drafting process. Thank you again. As I'm sure most of you would know, this current law was enacted in 2018 to replace the old law of 1987. Since 2018, when the law was first introduced, Bahrain also introduced a few amendments to improve the law further. These amendments were introduced, in fact, just a few weeks ago. Most significantly, the law introduced reorganization into the bankruptcy system that we have in Bahrain. Reorganization proceedings, which many of you would know is the equivalent of Chapter 11 of the US Bankruptcy Code. Under the old law, the only really practical, a viable court of proceedings available to a business entity facing financial difficulty was to go through liquidation, whereby the court would declare the business entity bankrupt and its assets would be shared by the creditors. The secured creditors would receive first from the collaterals that they have, and the other creditors would share pari passu in the proceeds of the sales of the assets that are available, assuming there are some assets available. Sometimes there's hardly any. So does Bahrain have a good law for reorganization? Well, the drafters of the law were tasked with developing a law that is in line with the best and most modern international practice in the field of insolvency. In the 2020 report that is produced by the World Bank on the ease of doing business, the World Bank, in fact, produced this report annually. In the 2020 report, Bahrain was given the highest score among countries in the MENA region for its insolvency law. I believe it would be fair to say that this score is a testament to the success of the drafters of the law and the legislative authority in Bahrain in developing a law that meets the highest standards. Since the 2020 report, as I said, Bahrain introduced some enhancements to the law, and the law is now even better than what it was when it was reviewed by the World Bank for the purpose of the 2020 report. So in future iterations of the ease of doing report that is produced by the World Bank, Bahrain should be even ranked better. The current law has two types of proceedings. Of course, one type of proceedings is liquidation. This is where, as I said earlier, the business entity would be declared bankrupt and its assets would be shared by the creditors. The alternative approach is for the company or the business entity to go through reorganization. Now, in a liquidation, the company would cease to exist. Its employees would be released. They would become unemployed. The business premises that the company occupies would be given up. So no more lease paid by the company to the owner of the real estate, and the company would stop producing products. It would stop producing its products, would probably stop exporting its products. So it would stop contributing to the economy. Now, the alternative approach is really to let the company continue to be reorganized, and this way the company would retain some of its employees, or probably all of its employees, will retain its premises, and it will continue contributing to the economy. If it produces some products, it will continue producing its products. If it exports, it will continue exporting. So generally, it will continue to contribute to the economy. And of course, this is really a much better solution as far as a company that is facing some financial difficulties is concerned. Now, in the application that is made to the court for reorganization, the applicant would have to specify that he's applying for reorganization, because alternatively, the applicant would probably be applying for liquidation. Now, faced with an application, whether it is for liquidation or reorganization, the court would have to look into the matter with the assistance of a provisional trustee that it may want to appoint. And based on the advice it receives, if it receives an application for reorganization, based on the advice it receives, maybe it would decide that no, actually reorganization is not viable for the business entity, and it should instead go through liquidation. Alternatively, if the application is made for liquidation, probably the court would decide against, based on advice and request by the creditors, that the company should instead go through reorganization. But having said that, even when the court initially decides to accept reorganization or to accept liquidation, later on in the proceedings, things would probably transpire, depending on also developments that happen in the future. The court would probably decide to convert the proceedings from reorganization to liquidation, or from liquidation to reorganization. There is a fast-track approach for reorganization, because reorganization can be somewhat a lengthy process. This is why there is a possibility under the law for a fast-track reorganization, or we refer to it in the law as prepackaged reorganization. This is really viable where the creditors are few, or where the bulk of the creditors, or the bulk of the credit really is owed to very few creditors. In this approach, the debtor will be able to negotiate a reorganization plan with these creditors, the very few creditors, and then he will go to the court to formalize the plan and to formalize the process. the reorganization would start under the supervision of the court. So this is what is referred to as a prepackaged reorganization. But some would probably say, why do reorganization through the court? Surely a company can reorganize itself. Surely a company can restructure itself, can streamline its businesses. Why does it have to go through the court to do reorganization? Well, usually one important thing that a company needs in order to be able to undergo reorganization is a protection, at least for some time, from its creditors. Probably some of these creditors have already obtained judgments against the company, and they would want to enforce their judgments, especially if they have some collaterals. Probably some already have obtained court orders for the seizure of the company assets, and some could be in the process of obtaining such orders. So such a company needs to stop all this, needs to stop these proceedings, needs to stop the seizure, needs to stop the enforcement against the collaterals that especially the security creditors has or have. This is the stay of all these proceedings is what is referred to as a moratorium. It's a moratorium on legal actions against the company. And this moratorium would kick in legally once the court accepts a petition for commencing the reorganization proceedings. But it's important to say that this moratorium is not absolute. But generally, really, this is one of the main reasons for a company to seek reorganization through the court. Joseph will speak in more detail on the moratorium. But an application for reorganization, the applicant for reorganization would have to satisfy one of this. Probably his application would satisfy two tests. What are these two tests? Well, the first test is what is referred to as cash flow insolvency or commercial insolvency. Can you hear me? Is my voice okay?
Yeah.
Yeah? Okay. So the first test is the cash flow insolvency or commercial insolvency. This is when the debtor ceases to pay or unable to pay his debts when they fall due for more than 30 days. There is cessation of payments of debts for more than 30 days. So this is the cash flow insolvency. The other test is the balance sheet insolvency. This is where the total liabilities of the debtor exceeds the value of his assets. So more liabilities, the value of the liabilities exceeds the value of the assets. But some would probably say, well, what's wrong with that? The company now has more liability than assets, but doesn't really has problems. True. This is why the court really will not apply this test literally. The court will have to decide, they will have to take into account the company's contingent and prospective liabilities, and will have to decide that based on a balance of probability whether the company will be able to pay its debts when they fall due. If the company is not able or will not be able to pay its debts when they fall due, then that test would be satisfied, the test of balance sheet insolvency. So who can apply for insolvency or reorganization under our law? Well, it's important to say that this test is really available to business entities, whether they are companies or they are sole proprietorships. The law is not available to individuals. Some countries have their laws applicable to both business entities and to individuals. Some have a separate law for business entities and another law for individuals. Currently, Bahrain's law is applicable only to business entities, and we do not have a law for insolvency or reorganization of individuals. The UAE recently introduced a law for the reorganization or insolvency of individuals. That was probably a year ago, and I would not be surprised if Bahrain in the future also introduce such a law, i.e. a law for reorganization or insolvency of individuals. So the law is available to business entities, but not all business entities. Business entities that are financial institutions that are licensed by the central banks are not subject to this law. These business entities, when they face financial difficulties, the relevant provisions of the central bank law would be applicable, not this law. So who may apply for insolvency proceedings? Who? Well, usually it's the debtor. Of course, it is the debtor who is usually interested in applying for reorganization. It is the debtor who is interested in obtaining protection from his creditors. Having said this, the law also allows the creditors to apply for the reorganization of their debtor. But what probably some would say, why would a creditor apply for the reorganization of his debtor? Well, sometimes creditors would want to avoid seeing the assets of their debtor dissipate gradually. They do not want to wait until their debtor apply for reorganization when it is too late for reorganization to be viable. Take this situation for instance. A debtor would probably, one of his businesses, probably his only business, is a franchise. And this franchise generates a good revenue stream, and it is worth quite a bit. Now, if he is having some financial difficulties and he goes to the court for reorganization, when the business is functional, when the franchise is functional, probably he would be able to sell that franchise for a reasonable amount of money. But if his situation continued to deteriorate, probably the franchisor would withdraw the franchise, and the debtor would be left with nothing. And in fact, he would not only be left with nothing, he would be left with picking up the pieces of the franchise. He would end up with premises which he has to pay rent for. He would have employees to pay their salaries, and so on and so forth. So it's important that the debtor really goes for reorganization at the right time. This is why the court really, or the law allows the creditors to apply for the reorganization of their debtors, because it's important that the application is made at the right time before it is too late. Of course, sometimes the debtor himself is a resistance to apply for reorganization because of the effect it would have on his reputation and the resulting reluctance of the market to deal with him. The process of reorganization would also affect his control over his business, because some of the control, if he goes through reorganization, so some of the control, or sometimes all of the control, would go to the trustee and the court. He also would have to put up with a significant public disclosure, which he would have to make of his debts, of his creditors, of his dealings, of his financial affairs, because all that will be required if he goes through reorganization. Now, what about the cost of reorganization? Well, it's not cheap. To start with, the applicant for reorganization would have to pay a court fee, which is not very substantial by itself. But later on, he would have to pay all the costs and expenses of the trustee, which will be appointed by the court, and would also have to pay all the experts, lawyers, accountants, managers, which the trustee would probably have to hire to enable him to go through the reorganization process. As far as SMEs is concerned, well, there is a provision under the law for the Minister of Justice to set up a fund to enable SMEs to shoulder the cost of the reorganization. This is discretionary to the Minister of Justice. The Minister has not used that discretion yet, but who knows, maybe in the future he would. Now, as a modern reorganization law, it very much emphasizes transparency and the participation of the creditors. A very important feature of the law, in fact, its emphasis on transparency of the proceedings. This by itself and other things helps to engage the creditors. One of these features that help transparency and engagement of the creditor is a requirement for the Ministry of Justice to maintain a register. This register contains almost all information on the case and progress related to the proceedings. The register is available at a website of the Ministry of Justice and is accessible to anybody. Another aspect that helps transparency and engagement of the creditors is the right available to the creditors to request from the trustee or the court information on the debtor's business and on his financial affairs and on all measures ordered during the proceedings that are related to the bankruptcy. One more aspect of the law which allows for the participation of the creditors is the appointment of a Creditors Committee. This committee is made up of unsecured creditors holding at least 25% of the total debts. The Creditors Committee oversees the proceedings and the conduct of both the debtor and the insolvency trustee. It has many powers under the law, including requesting the court to replace an appointed insolvency trustee. Another aspect of the law that provides for the participation of the creditors is the right given to the creditors to select the insolvency trustee. Following the selection by the creditors, then an appointment will be made by the court. These insolvency trustees are licensed by the Ministry of Justice. We have two types of trustees. One trustee is one type of trustees are the reorganization trustees. The other type are the liquidation trustees. Ideally, in a reorganization trustee, he really should have some experience in management of business and preferably the management of the business of the debtor, which is the subject of the reorganization. Now, there is usually a time lag between the time when an application for reorganization is made and the time when the court appoints a trustee and accepts the opening of the proceedings. Well, during that time, sometimes there is a need for some urgent measures to be taken. Some of these measures would be probably to order a stay of legal proceedings against the creditor, to order some measures to prevent the dissipation of assets, and even probably to appoint a provisional trustee to take charge of the business of the applicant or the debtor for some time, pending a final decision on the application for reorganization. Now, once the court is satisfied that the conditions for reorganization are satisfied, the court will make the order to commence the proceedings, and it will make arrangements for the selection of a permanent trustee. But even pending the selection of a permanent trustee, the court would have powers to appoint a provisional trustee. So now I reached the stage when the court ordered the commencements of the reorganization proceedings. Now the reorganization phase will start, and this is when the fireworks will start. That will be relayed to you by Joseph. So, Joseph, the floor is yours.
Thank you very much for that. Let me ask Mr. Damani, I want to be respectful of your colleagues and you and of the time. And so I guess I'd like to ask you, given that we want to reserve time for questions, how much time do you want me to spend on my
What do you think is a reasonable time that you need to explain the proceedings properly?
Well, I had planned about 20 minutes, but I can
No,
certainly
no,
make it
20
shorter.
minutes is perfectly okay.
Yeah. Okay. All right. And if you decide that it's going on too long, you just give the old heave ho or something. All right. So anyway, thank you to all of you for giving me this opportunity. And as you can see, I have flown in. I'm speaking to you from my penthouse on the 50th floor of the Four Seasons Hotel here in Manama, and it's hot here. So anyway, with that introduction, here's what I'm going to talk about. I'm going to talk about 4 parts of the reorganization process. The operation of and limits on the moratorium to which Dr. Jameel referred. Second, he referred to the fact that there's a trustee appointed who will be overseeing the reorganization case. So I'm going to talk about the powers that the trustee has. Third, I'm going to talk about the reorganization process itself, the formulation of the plan, and there's some aspects of that I'm going to get into. And finally, I'm going to talk about, well, so what's the bottom line? If the plan is approved, what does that mean? Those are the items I want to talk about. So first of all, by the way, get your fingers ready. You notice at the bottom of your screen there's a reactions tab. I may be asking you folks for a reaction to some of the things I'm going to say. So be prepared. So let me talk a little bit about the moratorium to which Dr. Jameel referred. And again, the basic idea of the moratorium is it's a statutorily imposed order that prevents automatically upon the commencement of an approval of the commencement of the reorganization case, it stops all collection and enforcement actions. And the idea is this will give the company a breathing spell so that it can stabilize, it can assess whether and what type of core business it really has, and it can formulate a reorganization plan. And it won't be picked apart by lawsuits all over the place. Now, the idea is to prevent enforcement proceedings by those pre-reorganization creditors who are trying to collect their debts or seize property. That's the basic rule. There are, however, important exceptions. So putting your thumb or your finger on that reaction tab, you'll see there's an option for a thumbs up, okay? So I want to get your reaction. See if you can tell where the line is where the moratorium applies and doesn't. So let's take the first case. Let's suppose there's a restaurant company. It's gone into bankruptcy. It owes 100 million Bahraini dinar to the bank that loaned it money. Do you think the moratorium prevents the bank from suing to collect on that money? If you think yes, thumbs up. And I'm seeing it on the screen from you people. Okay. And, let's see if there's other reactions. Okay. Yeah, I'm seeing some thumbs up. I think the answer is yes. All right. Now, suppose that this restaurant, Mr. Wakaba's come in. All right. Thank you, sir. So suppose that this restaurant company, it's got a bunch of restaurants, and these restaurants are violating all sorts of safety regulations. They're pouring poison into their food. People are being poisoned. Does this stop the regulatory authorities from preventing them from poisoning customers anymore? If you think no on your screen, give me a thumbs down. No, correct. Correct. Thank you, Mr. Juma and others. So the idea is the moratorium stops collection and enforcement actions on pre-reorganization debt, but it doesn't prevent continuation of criminal proceedings, safety proceedings, environmental proceedings. The idea is if a company is going to go through reorganization, it's got to be a good corporate citizen. It can't be violating the operation of laws for any other company. That's the moratorium. Let me talk about the trustee powers. So the trustee has a number of powers to stabilize, focus the business during the reorganization process. And the debtor, let's be clear on this, as Mr. Jameel or Dr. Jameel pointed out, there's a trustee appointed in. The trustee is in charge. But the debtor, the management, the owners of the company, they still have a continuing obligation and involvement and role to play in terms of continuing to run the business on the day-to-day basis under the trustee's direction. So this is really kind of getting the best of both worlds. We don't have a fox in the henhouse and that the management of the company that drove it into insolvency is still running it. They've got there's a trustee in there overseeing them to make sure they don't do bad things, but we're going to take advantage of their knowledge and experience with the business so we can operate it on an efficient basis going forward. The overall goal of the trustee in this process is to maximize the value of a business as a whole. And towards that end, the trustee has 5 powers at least that I think are worth noting. First of all, without court approval, the trustee can continue to operate the business in the ordinary course, including sales of goods in the ordinary course. So for instance, if we have a company that's a smelting company and it normally produces sheets of a rolled aluminum and sells it, and reorganization can continue to do that, doesn't need court approval, that's part of what their core business is, go ahead and do it. On the other hand, if there's some action that we're asking, the trustee is asking occur that's outside of the ordinary courts, trustee can't just do it. It's got to go to the court, it's got to give notice to all the creditors that it wants to take a certain action so that creditors can show up, object, make their appeals to the court, and the court will decide on the approval. So for instance, suppose there's a big conglomerate that's gone into reorganization, and it's got a chemicals business, and it's got a restaurant business, and it's got a department store chain. Those are all of its businesses. The trustee decides, that chemicals business, that's not a core business. That doesn't really work well. I want to sell that business off to a buyer. Can the trustee just do that? No, because that's a sale outside the ordinary course. The trustee has got to go to the court first, give notice in advance to creditors so they can show up and object to the sale. Maybe they'll say it's a core business. Maybe they'll say it is a core business. You shouldn't approve it, Judge. Or they may say, Judge, we agree that this should be sold, but the price that the trust is supposed to sell is a crummy price. There's a better price available, and we have a competing buyer here. Those are the kind of things that the court can decide whether or not to proceed. What's in power? The trustee can maintain beneficial contracts or leases, or sell profitable but unnecessary contracts or leases, or just repudiate burdensome contract releases. So for instance, again, suppose there's a company that's got a department store. It's a department store company. It's got a bunch of department stores, but some of those department stores are linked to go along with all the other unsecured claims against the reorganization state, which will be dealt with under the reorganization plan, and I'll explain that in just a minute. What's another power? The trustee can actually get loans or additional credit outside the ordinary course with court approval. So that's a way to finance the company as it's working its way, stabilizing its business until it's in a position to emerge. And finally, suppose that just before the bankruptcy, the reorganization, maybe a month before the reorganization, before there was ever a trial, and the owners said it's a department store chain again, and the owners decide, you know what, I have these 4 or 5 department stores which are really, really profitable. They got a great business. I'm going to give them to my sister. Just going to give them away. And then when I file for reorganization, they're outside of the moratorium. They're not. The reorganization law gives a bunch of powers to the reorganization trustee to claw back assets that were unfairly, wrongly transferred shortly before the reorganization process started, so that we'll have the maximum value available to the creditor body, the stakeholder body, to distribute among the reorganization plan. Now let me go on and talk to you a little bit about the reorganization process itself and the reorganization plan. And this is really the goal of the reorganization case, is to get a court-approved plan that will reset the capital structure of the company. And in that regard, here are some key provisions, 3 ideas that I want you to understand about the reorganization process. So first of all, the reorganization process and the law achieves reorganization through the adoption by the court of a so-called plan of reorganization. Typically, that's presented by the trustee after giving creditors notice and an opportunity to object. In fact, again, we've got this stabilization process that occurred because of the moratorium. The trustee gets an exclusive period in the first 3 months of the reorganization case to propose a plan to the creditors and the other stakeholders and to try and get their consensus and agreement to the terms of the plan. And the debtor is obligated to assist the trustee in formulating and soliciting support for the plan. Then, once the trustee has formulated a plan, it's not like it just happens. No, the trustee has to go to the court, which is a neutral party, and it's got to present the plan to the court and give the creditor body a chance to decide whether they're going to agree to that in effect, agree to that plan or not. The court's going to hear objections by the creditors to it. It's going to consider those objections and decide whether or not whether it will approve the plan or not. And essentially, there's a 3-month process, I said, for the trustee to get to formulate a plan. Then it gets about 3 months, an additional 3 months to get court approval. So if all goes well, the trustee can get 6 months to get the company reorganized. The court can extend that period, but the trustee has to go to the court, make a good case for it. Just doesn't get extended. These periods don't happen automatically. So what's the idea of a reorganization plan? What's it about? What the reorganization plan does is it resets the capital structure of the reorganized company, and it dictates the currency that will go to the various stakeholder groups: secured creditors, unsecured creditors, and others. And the currency can be cash, it can be new debt, it could be equity in the reorganized company, it could be a combination of all those things. As I say, it doesn't happen automatically. The various stakeholder groups get a chance to weigh in and decide, is that acceptable as a way to rebuild this company? Now, the reorganization law, here, I love to do this, so I can't resist, okay? So if you haven't been able to follow along, here's where I am. We're going to talk about that. Flexibility for the reorganization trustee in the form that the reorganization takes, all right? So the reorganization law gives the trustee great flexibility in the form of the reorganization. So while the business has been stabilized with the moratorium, and the trustee has been using these powers that I described before to get new credit, claw back assets that were wrongly transferred, etc., the trustee's laser focus is to try to determine the type of the business plan for this company that will do the best job of solving the debtor's financial and operational problems and maximizing the value of this bankruptcy estate, this debtor company, so that recoveries by the creditors can be maximized. So think of it this way. Think of a company as a balance sheet. And the left side of the balance sheet are its assets. And the stable amount right now, by getting rid of wasteful assets and focusing on the profitable assets, that's the left side. And once we get that left side of the balance sheet maximized, now we have on the right side of the balance sheet all these different creditor constituencies, and we want to divide up that value of the left side among the creditor constituencies according to their pre-reorganization rights. The reorganization can take many different forms under this reorganization law, best in class, really great, to achieve that goal. The trustee might decide that the best way to maximize value, this company just can't operate profitably. There's just no core business that really operates profitably. So it may say the best thing we should do is just have an orderly liquidation, not a fire sale where we sell everything off next week, but an orderly liquidation where we sell things off in an orderly manner. Or it could say, you know what? Let's have an orderly sale of the entire business as a whole, as a going concern, to a third party. That's a very standard form of reorganization that we see in the US under our Chapter 11. Or, this is the magic that I love, we could have a recapitalization. We're going to keep the company together, and we're going to convert some or all of the pre-reorganization debt into equity. And we're going to turn some of the creditors' claims, maybe all the creditors' claims, into equity of the new company, and we'll eliminate or vastly reduce the rights of the old pre-reorganization shareholders, so they have little or no equity interests. They get wiped out, and the creditors become the new owners of the company. Now, we can do that under this reorganization law just with an internal reorganization, or we can invite an outsider to inject new capital into the company in exchange for becoming an equity holder itself. Reorganization law allows this very flexible forms of reorganization to meet the specific facts and needs of the company. And experience has demonstrated that an orderly reorganization, whether it's a sale, a recapitalization, sale as a going concern, generally generates higher recoveries for creditors than a quick sale does. So let me talk about this. So as I said, the trustee can't just reorganize. He's got to propose a plan. And then it's got to go out to the stakeholders, and it's got to get court approval. So let me talk to you about the conditions that have to be satisfied for the plan to be approved. And the theme of all these conditions is to make sure there's fundamental fairness for all stakeholders. Now, I'm not going to go through all of the conditions, but let me outline maybe 6 or 7 that I think are key. And they're, in a sense, they're pretty common sense. One is we divide all the creditors and stakeholders into different categories so that each category has a creditor group that's substantially similar in terms of their rights, and they get the same treatment. So, for instance, if a company has it's worth its assets are worth $1 million Bahraini dinar, all right, that's the value of the company, and it has 800,000 dinar in bank debt. Let's say 600,000 dinar in bank debt, and the bank debt is secured by all those assets. We'd say that the bank is a secured creditor because it has a security right in those assets. It's going to be in a separate class from the holders of the unsecured claims. They're going to be put in a different class because they're unsecured. They have different rights to those assets. So we have claims divided into different categories. And the reorganization law contemplates that the claims of the secured creditors must get paid under the reorganization plan with cash, debt, or equity in amount equal to the value of their collateral securing that claim, up to but not anything more than the amount of the claim itself. So if the bank was owed 900,000 dinars, but its collateral was only worth 600,000 dinars, it would have a secured claim for only 600,000. Okay, that's its secured claim. That remaining 300,000 would be treated as an unsecured claim that's put in with all the other unsecured claims for treatment. Another requirement, creditors must get at least as much as they would get in a liquidation. Dr. Jameel said there can be a liquidation alternative to reorganization. Creditors should get at least as much as they could get in a liquidation under this plan. Otherwise, why are we doing a reorganization? It's a waste of money. Another requirement that doesn't have to prove it's an absolute guarantee will work, but he's got to show that it's reasonably achievable. It's likely that this company, when it emerges, will be able to continue to operate profitably into the indefinite future. Another requirement, it's not like the trustee just shows up in court. Before he can go to the court and ask the court approval, he's got to send out a detailed document, which we call a disclosure statement, that describes what the new capital structure will be to the stakeholders, will describe the new bank debt that this company will have, that will describe what the business plan is, so that the creditors and other stakeholders can make an intelligent decision whether to oppose the reorganization or to ask the court to approve the reorganization. Now, creditors get two ways to. First, they can object to the plan because, as I said, there are a bunch of statutory requirements that the plan must meet. And they can show up in court and say it doesn't meet one or more of these statutory requirements. And second, this is economic democracy in action, they can vote on the plan. Remember, creditors are divided into categories. And so creditors can vote in their applicable category or categories. Do they like the plan? Thumbs up. Do they not like the plan? Why are we doing this? So we want to make sure that there's weigh-in and buy-in by the creditors. Now, here's part of the magic of the reorganization process. You would say, well, we could do all these things outside of reorganization. Why do we need a reorganization process? We could have negotiations. Because there's always a hold-up problem from creditors outside of reorganization. There can be a dissonant creditor who won't agree and could throw things into chaos. But reorganization law contemplates that creditors vote by category, and as long as a statutory majority in a category votes for the plan, that's binding on the entire category of creditors and claim holders. That's treated as if that entire category voted for approval. What if there's one category that can't, one or more categories that can't even get a statutory majority? Are we done? Is it over? Can we not get the plan confirmed or approved? Wrong. The reorganization law has a feature that will let the bankruptcy court go ahead and approve a reorganization plan even if there's a holdout, dissident, troublemaking category of creditors that don't want to get the plan approved. It can still force the plan to be approved over their objection, but there's an additional set of requirements that must be satisfied by the trustee before the court is authorized to approve the plan. Now, if the plan gets approved, what's the consequence? Well, I think you've kind of gotten a feel for it already. All the pre-reorganization debt is discharged, meaning that creditors can only look to the cash, debt, or equity issued under the plan for payment by the company that's going through reorganization. And as I say, what that will be, what the payment will be to each category is set by the plan itself. And the plan will authorize the trustee and the court-approved management to enter in new agreements that set the capital structure of the reorganized company, or to sell some or all of its asset pursuant to the reorganization plan. The plan also provides for the expenses of the professionals that were incurred during the reorganization case, the people who lent money during the reorganization case to get approved. So that's how we can take this company, which was struggling on the verge of death, through rebirth, reemergence as an operating company. I hope I didn't overstate my time, but there it is. Thank you.
Wow, I think that was an extraordinary presentation by both of our speakers to take an incredibly complicated subject and to explain it in less than an hour. Really, really well done. Well, let's turn to some questions. As our speakers were talking, I saw some come up on the screen, and There are a few others that I think we should raise. One excellent question that came up on the chat feature is someone was asking, well, what's the time frame to complete the reorganization process? You mentioned that the trustee has 90 days to come up with a plan, but is there some other time frame from the start that the case has to be concluded within a definite time period?
I'll take that one to start. The statute doesn't set a deadline for the case to be concluded. But remember that the trustee has only an exclusive period to propose a plan of 3 months, and then another, if it does propose a plan, another 3 months to get it approved. If the trustee doesn't meet those deadlines, then creditors or the Creditors Committee, to which Dr. Jameel referred, they can come forward and they can propose their own alternative plan of reorganization. So the fact that there's a deadline to propose these plans, or else somebody else will show up with a plan, that puts pressure on the trustee and the debtor. They got to get it together. They can't just linger in bankruptcy, enjoy the benefits of the moratorium. They got to get their act together. Other people are going to show up and they're going to take over the reorganization case.
So there's not a definite deadline. It sort of depends on the complexity of the case. Some cases are easier to complete quickly than other cases, I suppose.
Right, right. And as I said, the trustee can get extensions of time to propose a plan or get it approved, but it's got to get court approval. And conversely, the Creditors Committee or creditors can go before the reorganization court and say, shorten the time. The trustee's doing nothing. We got to get action. But again, they got to get court approval. So we always have a neutral arbiter in the form of the court to resolve any disputes about how the reorganization case is being managed.
You know, another question that I see is a question of the role of secured creditors and how they're treated. Both of you mentioned the moratorium applies to secured creditors. And so during this period, while the plan is being discussed and negotiated, the secured creditor is not permitted to seize its assets as it would otherwise be permitted to do. So how is the secured creditor protected? How does he protect his collateral? Is there some rights the secured creditor has? Does the trustee have to do something to preserve or protect the collateral of a secured creditor during the period of the moratorium?
Okay, great question. Thank you for that. A few comments. Number one, remember that the trustee can use all the assets of the reorganized company in the ordinary course, and that includes the collateral of the secured creditor. But if the collateral is going to deteriorate in value, the secured creditor can go to the bankruptcy court and ask the bankruptcy court to lift the moratorium so that the secured creditor can go ahead and seize its collateral unless the trustee can demonstrate to the secured creditor and to the court that the trustee is taking some action to preserve the value of the collateral as it stood on the date that the reorganization commenced. In other words, he's got to be, if it's machinery and it's going to be wearing out, trustee's got to make sure that he's, fixed it, insurance like that. What the collateral is cash. It's actually proceeds of inventory. Can the trustee use that in the ordinary course? No. On that, because cash is so fluid, the trustee actually has to get court approval to use cash. The real world experience has taught us, again, this is like our U.S. bankruptcy law, one of the key negotiations for the trustee at the outset of the bankruptcy case is to negotiate with secured creditors terms under which the trustee can continue to use the cash that the company is generating that consists of proceeds of the collateral. You might do it by giving a replacement lien on other assets of the collateral of the estate. What if it's going to be used collateral outside the ordinary course? That's collateral of the secured creditor. Again, trustee can't do it unless it gets court approval, and there the secured creditor can show up and say, the trust wants to do. The court can make a decision on that.
I think it's important to emphasize that the secured creditor should not be harmed by the reorganization proceedings. Whatever is done during the reorganization, the secured creditor should not this safeguards so that they are not harmed. Now, having said that, the trustee from even selling the collateral of the secured creditors, subject to certain safeguards that are provided in the law. Sometimes, really, it is in the interest of the bankruptcy estate to sell the collateral. That can be done, but it should not be really sold for less than its market value, and it should be
of rolled aluminum. Yeah, the secured party, the trustee can sell that inventory, but the payments that come in, the condition is the trustee cannot use any of those payments come in unless it protects the right of the secured creditor. In other words, the secured creditor's security right attaches to those payments as proceeds. Trustee can't use any of those payments unless the court approves it in a way so that the value of the secured creditor's security right is preserved.
Thank you. That's very helpful. Another question that's come in, which I think is a very good one. I think this really is best for Dr. Jameel, which raises the question of, well, sometimes courts are not prompt in issuing their rulings, and that delay can be harmful to the process of resolving the company's insolvency case, whether it's a liquidation or a reorganization. So is there anything in the law that compels the court to rule promptly, or how does the law try to deal with the problem of court delays?
Well, the law very much emphasizes the need for expediency in the course of proceedings. And generally, this is really interest of the assets into consideration. Sometimes a hasty decision would really mean doing it in the absence of the creditors and without involving the creditors, without engaging the creditors. So the creditors would have to be engaged in the process. And yeah, sometimes that really delay the decision.
Joe, from your perspective, US, did the creditors or the debtor, how do they deal with the judge that seems to be sitting on motions and applications?
Well, again, it's such a transparent process in the U.S., and I expect it will happen here. First of all, our experience in the U.S. is judges are very sensitive to the idea that certain issues are really time urgent. And because it's the transparency of the process in the U.S., which I think the law in Bahrain contemplates, creditors have the right always to go before the court and say, Judge, we need a ruling on this issue. Or the debtor can say, Judge, we have to have a ruling on this issue because our company is like a melting ice cube. And if you wait, the ice cube is going to get smaller and smaller. There's going to be less value available for everybody. And that I found very compelling to bankruptcy judges.
Okay, another question that goes to the relationship between the debtor, and it's the management of the debtor and the role of the trustee, and it goes to the point of if what is the trustee's power, and how does he deal with a situation where it seems like the plan in the trustee's mind that's being proposed or pushed by the debtor and its management is not realistic. How does that process play out under this law? Is the final sayer of how to move forward the trustee, or does the debtor have the ability to insist on the idea of a plan that the debtor and its management has?
I'll take that one. Great question. All right. To be really clear, the debtor has the obligation initially to present the trustee with a form of plan, but the trustee is not bound by that. And if the trustee decides that's not realistic, that doesn't make sense, that's not consistent with people's right, it's the trustee's final decision as to what plan to propose to the court and to the various stakeholder groups. The debtor doesn't have the ability to overrule the trustee. The trustee has the power, the final say on this.
I think it's fair to say that usually it's the debtor who really knows best about his business.
He does.
Quite often he knows more about the business than the trustee. This is why the law says it is really the debtor who has to provide a draft reorganization plan, and then that will be really formalized by the trustee.
Yeah, I think that is one of the really the best features of the Bahrain law, is that it has the trustee that has ultimate responsibility and who's familiar with the insolvency process, but it also provides an important role for the debtor that is able to provide that business input as to how to best maximize the value of the assets. I think that, in my judgment, is an improvement over the U.S. model, where the debtor has exclusive control but doesn't have the assistance of the trustee. Let's see. I see another question that goes to what happens if there's a problem after the plan is approved in its implementation. If, for example, the plan called for the investment of new capital into the company and that doesn't happen within a certain time frame, how is that dealt with? What happens to a plan that is not being properly implemented?
Well, the reorganization law provides a process so that after plan approval, but before implementation, if there's some snafu occurs, or problem occurs, such as somebody who was going to provide new capital backs out, it provides for the trustee to go back to the court with an amended plan that revises the terms of the plan so as to recognize a change in circumstances. Again, that has to get court approval.
Yeah, I mean, this is really one situation where a plan has to be revised. I mean, after all, a plan is not really engraved in stone. The plan is definitely made based on certain assumptions. And after it is approved, things probably change. And as a result, there's at least sometimes a need for the plan to be enhanced, revised, modified, to make it workable, or even to improve on it further.
And experience has shown in reorganization cases, nobody wants to go back and revise a plan that's been approved. So just experience has shown that when companies are putting forward reorganization plans, and those plans assume, for instance, there'll be new financing that will be provided, or there'll be a new key contract that will be at the core of the reorganization. The people who are putting together plans are pretty careful to get those counterparties to lock into their commitments so that they can't back out as long as the court approves the plan within a certain period of time and certain other conditions under the control of the reorganization trustee have occurred. So we don't get this stutter step emerging from the reorganization approval.
Dr. Jameel?
Can I present a question?
Mr. Khalid Zayani.
Jameel, I want to address a question to you in particular. You know the state of our courts in Bahrain. Sometimes they don't make decisions very quickly. Is there in this particular law a system by a time bar on their decision making?
Well,
Sometimes you lose simply.
I think it is fair to say that the courts in Bahrain have really improved a lot over the past 2-3 years, and things now are moving much quicker. But in this particular law, really, there is emphasis on speed. There is a requirement, really, a specific provisions in the law which calls for decisions to be made, in a quick manner.
I haven't seen that, and I can quote you an example. A company that went bankrupt, and it is now in bankruptcy. People who sold goods, and those goods are actually in the name of the seller. And they cannot repossess their goods. And the value of these goods are deteriorating day after day, especially if the goods are cars. And the distributor suffers. And this is not only to our group. I'm talking about practically all motor distributors in Bahrain. This is a fact and still exists. And it's been years we can't get back our cars. And in fact, some of these cars were dismantled as spare parts and sold as spare parts. And the court is not taking any action.
Well, you're talking about years, Abu Nawaf. This is really, maybe it's a bankruptcy that is subject to the old law. This is a new law, and it has a much better provisions than the old law. But of course, I cannot really comment on the particular case that you are referring to because I really don't know the facts. And, maybe this is something which is better addressed by the Ministry of Justice, of course.
And the Ministry of Justice does not reply to questions in person, in writing, or accept us talking to them. I'm not talking about us. I'm talking about all car distributors.
Well, as I said, I don't really know the particulars of the case, but
this new law provide for speed of execution.
Yes, this is very much what this current law provides for. And generally, I think, if you look at the statistics that are produced by the Ministry of Justice, you will see that there has been a lot of improvement over the past 2 years as far as, resolving cases are concerned. And hopefully things will become even better in the future.
Dr. Jameel, if I can just jump in, if you don't mind, 2 cents on Mr. Khalid's question. By speed, I mean, there's 2 explicit things that come to my mind, and please do correct me if I'm wrong. You're definitely more of an expert in the. But first is that there are streamlined court proceedings. Yani everything goes through one specific high court in Bahrain. Anything related to R&I, when it's under the auspices of this law, goes to that one court, and the idea is to slowly build the expertise in that court. Today, after 2018, the law has just recently been passed, very lightly been tested, so it's still pretty much very academic. So in this short period, there's definitely going to be teething problems, but the idea is to slowly build an expertise with that higher court. The other thing that I can think of in terms of speed or recovery is that you don't have the standard, typical, plain vanilla processes of appeal that you would have in a normal court proceeding in Bahrain. So I think you can appeal it once. That's something that Dr. Jameel has to confirm. but there are limited avenues to appeal. Again, to make it shortened as much as possible, but there isn't a hard and fast black letter law that says this is how long, or this is the hardening period. This is exactly how long the case will go for. Correct me if I'm wrong, Mr. Dr. Jameel, but I think that's my 2 cents on this point.
Yeah, I'm not sure really that it is really possible to put any fixed date for a case to finish or for rulings to be made. But I mean, the law, I think the really sensible thing that it can do is to emphasize the need for speed. And the rest really is up to the courts. Now, as far as appeal is concerned, well, there are certain rulings by the court which can be appealed, and the appeal is straightforward. Really, it's you have to appeal within 30 days after the ruling is made. But before you do that, on certain matters, you can still submit a grievance to the same court which issued the ruling, and once the court issue its final decision, its decision this time will be a reasoned decision, and then you take those decisions and you can appeal to the Court of Appeal. But as you said, there are always these teething problems, and the reorganization itself is something very new, and I think it's fair to say that things would have to improve with time, are bound to improve with time.
David, back to you.
One interesting issue under the new law is how it applies to the guarantors of a company's debt. And so if the owners of the company had guaranteed a loan to the bank and the company goes in to reorganize, does the guarantor get protected by the moratorium and get the benefits that happen to the company in the bankruptcy proceeding itself?
Not at all. The guarantor really has no benefit at all from the moratorium. The moratorium would really benefit the debtor only, but not his guarantors.
So in essence, in order for the guarantor to get the benefits of the insolvency law, the guarantor has to commence a case for the guarantor.
I guess as a debtor, yes, but he will not really benefit from the moratorium.
It doesn't benefit
as a guarantor.
Yeah, as a guarantor. Let's see.
Can the guarantor come under a different classification to secure his rights?
Well, he really has. He has to be a debtor. I mean, if he is a debtor, and his debt here is a contingent debt, then yes, he would be a debtor, and he would have to join all the other debtors, but he would remain a guarantor. What's the experience, and how's this looked at, Joseph, in the United States?
It's as you said, if the guarantor wants the protection of the moratorium and doesn't want creditors to start suing the guarantor or seizing guarantor's assets, guarantor has to file its own Chapter 11 bankruptcy. And now it's put all of its assets under the control of a trustee, may be able to lobby with the trustee, argue with the trustee about how they should be used, but that will be under the control of the trustee. In the U.S., we've developed some rules so that when related debtors go into Chapter 11, like a guarantor, a main company, subsidiaries, some of which may or may not have guaranteed the main company's debts, we've developed some procedural administrative rules that all of those reorganization cases are heard together by the same bankruptcy judge so that they can be dealt with as a collective whole and administered as a collective whole. That doesn't mean all the assets are just glopped together in one big pile. No, their assets are still their individual assets. Their debts are their still debts. But administratively, we can administer them together so their connections between the debts can be dealt with efficiently. So how we deal with the debts of the guarantor will be sufficient also and appropriate to also deal with the debts of the primary debts of the primary company.
David, perhaps 3 more questions before we close the Q&A session.
Okay, I see that on the chat, someone is saying they have a few questions. I don't know if you can see that as well, or Reem
Yes.
can.
Okay.
Hi.
Okay. How many questions are there?
Oh, sorry. Yeah, I had a couple of questions. I didn't list them. We've been working a lot. I do R&I in Baker McKenzie. I'm a partner. I have, I think, 5 associates on the line. I'm sure one of them, Abdulrahman, also has a question. My main question is, I actually have a question and a few feedbacks or remarks, if you like. I'll be very short. The question is, under most insolvency regimes, legal frameworks, the debtor is under a very strict legal obligation to cease complete business if insolvency is inevitable. So in theory, the continuation of business would literally put the directors, the shareholders on the line. If the business is in actual distress, it's no longer viable, etc. So these triggers of bankruptcy-related penalties on directors and potentially shareholders of the debtor are not, at least in my view, explicit or very clear in the Bahrain bankruptcy law, as opposed to others like the Saudi one, which me and my team work with more than the Bahrain one. So I was just wondering if Dr. Jameel, that question is addressed mainly to you, if you have any thoughts on that. The other main thing that I wanted to mention, we don't need to reiterate the teething problems and the fact that we need some more expertise in R&I for trustees and for judges and all of that. But there's one thing that I think is instrumental, which is we really do lack a mature DIP financing market or debtor in possession, new financing market. This is natural, obviously, given the laws in its infancy, but I think creditors are still susceptible in this market when it comes to increasing exposure to an already distressed entity. And I think, I don't know how we're going to go about that, because it's one thing to train experts or to bring experts and to train judges to raise awareness and provide some sort of a supervising body to all the constituencies working in this field. But it's another thing altogether when there isn't an actual voluntary DIP financing market. Because this is something, as you would know, Joseph and maybe David, is very important in the success of these reorg frameworks, and is a major success of Chapter 11 in the US because of all these hedge funds that come in and inject all this new money into these distressed entities during the distress and obviously receive the super priority ranking, etc. So that's a main and one point. The last point is moratorium, unlike Chapter 11, is not automatic in Bahrain. And I don't think this is very problematic maybe in the long term when we are over the quote-unquote teething problems. But I think the real-life issue we've seen with Garmco, which is a very big client of mine on another case, not on the restructuring, is that the court took, I don't know, I think it was over 5 weeks or 6 weeks or almost 2 months to approve the case. So the Garmco filed, it was a debtor-led reorganization. They filed on the 8th of January, I think. And I think mid to third week of February, the court approved. And the way the moratorium works, which is a massive protection, is it only works after the court approves, unlike Chapter 11. And I guess one possible development in the future is to make the moratorium automatic on application until a court renders its decision, because if there are more of these GARMCO repeats going forward, a lot can happen in 2 months because everybody's put on notice, including the creditors, and there's no moratorium protection, which kind of goes against the whole concept of the moratorium. And sorry, I just said these 3 random questions behind each other, and I think Abdulrahman Al-Majdoub, are you on the line? If you can jump in with yours also so that you can...
Yeah. Hi, everyone. Thanks, Fatima. I have just a small, quick question about the application of the bankruptcy law to financial institutions. We know that the bankruptcy law does not apply to entities licensed by the Central Bank of Bahrain. And so I guess my question is, why were they excluded? And I guess, wouldn't it be better to have a harmonized insolvency regime? Thank you.
Let me start by answering that, and then Dr. Jameel, take it away from me. But if I can answer these kind of out of order. In terms of the question about debtor in possession financing or obtaining credit, I think Ms. Al-Hassan, I'm sorry, I just butchered your name. I think you make a good point, which is there's got to be a market of lenders out there who are interested in providing this financing. And from my perspective as an insolvency lawyer, I feel like this is a rich opportunity for lenders here in Bahrain, because what we have learned in the U.S. is DIP financing, debtor in possession financing, obtaining credit, is the most secure form of lending a lender can have. It is the best lending. Why? Because lenders who make so-called debtor in possession loans in the United States, they get a court order approving their loan, approving the terms of the loan by court order, federal court order. This is the U.S. government saying, your loan is secured by the following assets. You don't have to file any other paperwork. This order makes it so. And the court order also says, you're at the top of the heap. You have got to get paid off before anybody else can get a nickel. And there are a whole bunch of procedures under our insolvency law, which I believe this insolvency law echoes, to make sure that they always get paid off in full. Our finance community here in the U.S. has figured it out, and typically in a reorganization case in the U.S., there becomes sort of a feeding frenzy among the lenders about, I want to be a lender, I want to be a lender, which is great for the company because it can get a bidding war going. I can't speak to the finance market here in Bahrain. That's kind of outside the scope of this law, but there's an opportunity here waiting for financiers. So if you know anybody in hedge funds or banking or whatever, tell them this is their opportunity. On the question about the moratorium, you pointed out an interesting difference from the U.S. In the U.S., when the application is filed to commence a bankruptcy, we call it the petition, the automatic stay, the moratorium goes into effect that moment, not at the moment when the court says you're in bankruptcy. Actually, the way our reorganization law works a little different is in our U.S., if the debtor files for bankruptcy, automatically the moratorium goes into effect, and the debtor, the company, is in a reorganization automatically, immediately. There's nothing for the court to decide. It's only in the U.S. if creditors ask for a bankruptcy or reorganization that there's a gap period waiting for the court to decide. But even in that case where it's a creditor-initiated insolvency proceeding, it's when the petition is filed rather than when the court orders it that the moratorium takes effect. That is a difference from our U.S. law. And finally, to the question, financial institutions, this is somewhat outside of my scope, but I'll tell you, we have the same rule in the U.S. Banks, insurance companies, they are not covered by our U.S. Chapter 11. And why is that? Because they're heavily regulated by other government institutions already. So there was a feeling we don't need to have Chapter 11. They already have a regulatory process that deals with insolvency.
Yeah, I mean, this is really very common around the world that financial institutions really are not subject to the same bankruptcy code that is applicable to other commercial companies. So we took the same approach, especially the central bank law has some provisions that deal with the difficulties of these institutions. Now, as far as the moratorium is concerned, yes, Bahrain law, under Bahrain law, the moratorium is not automatic, does not kick in upon application, upon the submission of the petition for bankruptcy. But there is a possibility under the law for conservatory measures to be ordered by the court before the court ruling on the petition. So there is nothing to stop the applicant from day one when he lodges his petition with the court to go to the judge and apply for conservatory measures. And these conservatory measures may include an order for moratorium. If not on all proceedings, it can be on some of the proceedings that are going on. The judge really would have to be satisfied that this is in the interest of the bankruptcy estate and the interest of the reorganization. This is really the approach that we took. So, you know, if there is a case for the moratorium to kick in from day one upon lodging of the petition for the reorganization, then the court would order that moratorium to kick in from day one. Now, as far as the authority of the directors and managers and whatever of the debtor, well, the default rule is that these guys will continue managing, the debtor will continue managing its business, provided that the things which he's doing is in the ordinary course. But if the court is satisfied, the trustee or the creditors can apply to the court and can request the court to restrict the authority of the debtor over his business. And in fact, the court will have the authority to order the debtor to relinquish completely authority on his business, and everything will be taken over by the trustee.
Well, shall we go ahead, and are there any other questions, or should we say this is a mission accomplished?
Well, mission is almost accomplished.
Okay,
the last question for Mr. Zain.
There we go.
The last question. You are leaving a doubt because the judge is still has an authority to decide or not decide protection. The whole idea of the law is to make the company able to survive, to revive its business. And what if, like Gramco, takes about 2-3 months before something is decided upon? There is a flaw there. And Jameel, you are a smart guy, you're a businessman in thinking, you come from a business family. This must be addressed. We either have a law which serves the purpose, or we are subjected to a judge who doesn't understand a thing about business. We need to hear from you and put some pressure on the law to be amended for the purpose of existence.
Well, Abu Nawaf, life is like that. Judges rule on everything. From divorce and marriage, custody, to banks and companies and insolvency. Now they rule on all sorts of technical matters, medical issues, but
of this law, the idea of having this law is to protect a company while it's in difficulty, and that should not be subjected. The timing of it should not be subjected to the whim of a judge.
Well, I would like to think that really it's not nothing is subjected to the whim of the judge. Judges would really reject that. But I think, as I said, judges rule on medical matters, on banking matters, on everything. But they do such a ruling based on advice that they get from experts. So, whether to accept a petition for bankruptcy or for insolvency or for reorganization, the judge would make a decision. Really, nobody else can make that decision. But he would make that decision based on the advice that he gets from the trustee that he appoints. And he would also have to listen to the creditors. They would not really make a ruling without listening to the creditors and without listening to the trustee.
Mr. Al-Zayan, if I could just ask, is your biggest concern about the timing of the judge making the ruling?
Absolutely. They have absolutely no idea of business and how it is run.
So
they will let a company drag on, and they don't care. They simply don't care. There's nothing burning inside them to satisfy a purpose that they were put there to satisfy. They just don't care. Time is, so what?
Yeah. So if you became comfortable that, in fact, when issues were put before the judge and that the judge would rule promptly, how do you feel about this law as we've described it today?
The law is good, but what I heard from Dr. Jameel is something worrying, that the clock doesn't start except after the judge goes to experts and speak to debtors and speak to God knows who, and then he makes up his mind. And take a case like Gramco, you said it took over 2 months. I want to see how fast, how capable a judge in Bahrain to decide what's important for Gramco, what is urgent or not. We don't have a judge in Bahrain capable of thinking in that manner.
Well,
the clock. Sorry, go on.
In fact, a Bahraini judge, or under this law, a judge will be able to decide from day one. As I said, from the time the application is submitted, he can order conservatory measures without even listening to anybody. But these are really conservatory measures until he finally make up his mind. These are not permanent. The moratorium is temporary until he makes up his decision after he listened to the experts. But from day one, in chamber, you go to him and he will have the power to order conservatory measures. And one of them, of course, one of these conservatory measures is ordering a moratorium. Without listening to anybody.
Perhaps I think I agree with what Mr. Zayan is saying. Maybe just a suggestion here, of course. I would be happy to have a rule which is very similar to what the US has, that the moment you apply for reorganization, it immediately takes place. And then the judge comes in and takes the decision whether it should go for reorganization or bankruptcy. This way, it'll push the judge to take an early decision whether it should, allow bankruptcy or not. The reverse way will put pressure on the judge to take a decision. But in the meantime, the business is at least protected.
That's what I'm hoping to hear.
Well, I mean, there is this possibility for the moratorium, as I said, to kick in from day one, but you really have to satisfy the judge. From the time the petition is submitted, you go to him in chamber, and he has the power to order the moratorium to kick in. Now, the other side of the coin is if you allow the moratorium to kick in from the time the petition is submitted, this can be subject to abuse. This is why this system is not really followed by all countries around the world. In fact, most of them, I would say, they do not have the moratorium kicking in from day one. But if the court is satisfied, if the judge is satisfied, it can be kicking in from day one. But not this is not the default rule. There are two schools on this. Most countries really follow, I think, what we have.
Anyway, I think we have got the topic going. We have got everybody thinking and talking about it. That's a good start. David, I'll give the mic to you, or sorry, the platform to you for your thoughts before we close the session.
Well, I'd like to thank both of our speakers for illuminating all of us about the new law and the opportunities that it provides to deal with insolvency cases in Bahrain. As I said, I think it is a best-in-class law, and I think that now that the pandemic has arrived, there are going to be increasing numbers of insolvency cases, and I think this is going to arm Bahrain with really the law that it needs to be able to best deal with those problems. To enhance everyone's understanding of the law and what it can do by listening to the questions that came from everyone. So thank you very much.
Thank you, David. I would like to take this opportunity once again to thank our speakers, Joseph and Jameel. Excellent. Normally lawyers complicate issues, but for once you all have simplified issues. So thank you.
Thank you.
And David, thank you for being an excellent moderator. I always say the moderator makes or breaks a session. I think you did an excellent job. So thank you very much for your moderation. And once again, I would like to thank everybody for joining in and being patient. And I think it was a session which was nearly 2 hours, and most of the people have stayed in. So that shows perhaps the interest of the people and how relevant the topic is. I would again like to once again thank my board for being very active. I think, as our Vice Chairman Abdul Rahman said, that we are trying our best to bring in more of these sessions, which are becoming popular. We can see from the attendance. If there's anything that we can do, I would request our members and guests to let us know how we can make this platform better. I would like to end once again by thanking everybody. Joseph, all the best, and David, to you at Chicago. I hope everything goes well. And Jameel, thank you very much for bringing in the speakers with you. I appreciate it, an excellent event. Thank you, Thomas, our board member, for getting the speakers online as well.